A discussion on the office of the governor yesterday. So who is the governor? The governor is the office of the governor is appointed by the executive. He is conceived to be the executive head of the state. He holds office during the pleasure of the president. Now, what is the meaning of pleasure principle? It means that the president of India can at any given point of time remove the governor from office, and the president does not have to give any valid reasons. The president does not have to give any valid reasons for any such removal. Though he has a tenure of 5 years, the constitution mentions he has a tenure of 5 years. He has to be 35 years of age, being qualified to be a member of Rajya Sabha. He is a ceremonial head of the state, and also now when we look at the office of the governor, though he is conceived as the executive head of the state, but the office of the governor is said to have dual responsibilities or a dual role. What is that dual role? To act as the ceremonial head of the state. That means because we have an elected legislature, even at the state level. So there is a council of ministers, and these council of ministers are headed by the chief minister, and it is considered that the real executive powers will lie with the council of ministers headed by the chief minister, because this is the democratically elected. These are the individuals who are democratically elected, and it is this group of individuals who enjoy the confidence of the people. That is the reason why the office is conceived only as a ceremonial executive and not the real executive. So in virtue of this position that is held by the governor, that is, he is a ceremonial head of the state, his constitutional position is very similar to that of the president. But he also acts as the representative of the center, which means because he is appointed by the president, he is appointed by the president, it is also expected from the office of the governor that he will be a link between the center and the state, because the appointment is made by the president. He is acting or holding office during the pleasure of the president. He is holding office during the pleasure of the president and is acting as the executive head of the state. So it is conceived that the office of the governor will act as a link between the center and the states. The 7th Constitutional Amendment Act that was taken up in the year 1956, this 7th Constitutional Amendment Act authorized an individual to be appointed as the governor of one or more states and UTs. Clear? However, when we say the office of the governor, now the office of the governor has dual responsibilities and he acts as the representative of the center. This responsibility is also criticized. Sometimes the office of the governor is also alleged to be an agent of the center. Rather than just being the representative of the center, the office of the governor, he becomes the agent of the center. When we say this agent of the center, this role of the governor as an agent of the center, this role is very much visible in the post-1967 era. Why? Why 1967? Yes? Yes. It was since 1967 that in India we see the rise of competitive politics. What we see is the rise of competitive politics in 1967, because it was since 1967 that we see that the regional parties and parties that were other than the Congress party, these parties come to power in the states in the 1967, and since the 1960s what we see is a different role of the governor that comes up, and that role is not just merely acting as the representative of the center to ensure that there is a link between the center and the state, but the office of the governor. The office of the governor is basically being used as an agent of the center. He is being used as an agent of the center. Post 67, rise of competitive politics. Rise of competitive politics gave rise to combative federalism in India, and the office of the governor became one of the tools in pursuing combative federalism. It becomes one of the tools in pursuing combative federalism, the other being the use of Article 356 of the Constitution, that is the proclamation of President's rule in the state. So what we see is the coming up of the office of the governor, and that governor, the office of the governor turning into from being just a representative of the center to being the agent of the center. This competitive politics or this idea of combative federalism, it continued till the year 1994. It continued till the year 1994. 1994 because 1994 was considered to be a watershed, because there was something called as the Supreme Court's decision in the SR Bommai case. And since the SR Bommai case, the manner in which Article 356 was being used or misused, and how the office of the governor was the chief instrument or the chief architect to misuse this Article 356. To a certain extent it was stopped. Now, if you look at this agent of the center role of the governor, the agent of the center role is also very much visible when it comes to the office of the governor. The reason being that the governor does not enjoy the similar position as that of the president. That means his constitutional position is not similar to that of the president, and there has been number of reasons in this regard. One of the most important reason being that though we conceive the office of the governor as only a ceremonial head, but the office of the governor also enjoys, the office of the governor does enjoy some executive powers. In fact, if you look at the constitution says there shall be an office of the, there shall be a council of minister headed by the chief minister to aid and advise the governor, which is similar to what what we have seen in relation with the president and the council of ministers. There shall be a council of ministers headed by the prime minister to aid and advise the president. But unlike the president, which the office of the president is being constitutionally dependent. The office is constitutionally dependent upon the office of the council of ministers. That is not the case when it comes to the office of governor. The office of governor is only constitutionally dependent upon the office of the council of ministers only in those cases wherein the constitution does not prescribe the office of the governor to act in his discretion. Because the constitution, unlike the office of the president, which mentions that we have seen there is no constitutional discretion that the president has, that is not the case when it comes to governor, and the governor has some explicit constitutional discretions. And the constitution goes to an extent wherein it does not just give discretionary powers to the governor, the power to determine what is the discretionary power of the governor also lies with the governor. And the constitution mentions that any doubt with respect to what is the discretionary power of the governor, the decision therein lies with the governor. And his decision in this regard is final and binding, which means if he takes a discretionary action or takes a discretionary decision, it cannot be challenged in any court of law. It cannot be challenged in any court of law. Not only does the office of the governor enjoy some discretionary powers, various provisions of the constitution also prescribe for some set of responsibilities and duties which have been given the name of special responsibilities of the governor. So while the governor is exercising his discretionary powers, the governor is not bound to consult the council of ministers. The governor is not bound to consult the council of ministers, and the governor can act in his discretion even without the aid and advice of the council of ministers. While discharging his special responsibilities, which has been mentioned under Article 164 and Article 371 of the Constitution, the governor, though is bound to consult the council of ministers. So aid and advice, the mechanism of consultation is not a discretion, it has to be done, but whether the governor accepts such an advice or not, it is completely up to the governor. The governor may not accept such an advice, despite the fact that it is mandatory for the governor to consult the council of ministers. But it is not mandatory for the governor to act in accordance to the advice, aid or advice given by the council of ministers. So not only does the office of the governor enjoy discretionary powers, but the office of the governor also enjoys some special responsibilities. And that is the reason why when we look at the constitutional position of the governor and compare it to that of the constitutional position of the president, we find that the office of the president, the office of the governor is much more secure with respect to its council of ministers than the office of the president with respect to their council of ministers. The Supreme Court has gone to an extent wherein the Supreme Court has said that the office of the president cannot exist. It is constitutionally imperative for the president to have a council of ministers. That is not the case when it comes to the office of the governor. And the office of the governor can exist without the existence of a council of ministers. And you can see this when president's rule is imposed. When president's rule is imposed, the council of ministers are dismissed. And president's rule imposed, when president's rule is imposed, the constitution under article 356 says that the president will assume the executive responsibilities of the state and will exercise these executive responsibilities either directly or through any other office. So he may not necessarily, the president may not necessarily enjoy all these functions directly. The president may enjoy these functions through the office of the governor. It is generally the governor through which the president exercises or assumes all the executive powers of the state when the president's rule is imposed. And during this particular period, the office of the governor is present and is acting as the executive, the real executive of the state, despite the fact that there is no council of ministers. The state legislature may also have been dismissed during this period, and it is not mandatory for the governor to exercise his powers only in accordance to aid and advice that is given by the council of ministers. So we say the constitutional position of the governor is much more secure vis-a-vis its council of ministers when we compare the constitutional position of the governor and that of the president. We say that the office of the president enjoys influence but not authority. It enjoys influence, and you can see suspensive veto, reconsideration. These are what? The mechanism through which the president is enjoying influence, not authority. But the office of the governor, not only does it enjoy influence, it also enjoys authority. So though the constitution conceives the office of the governor as a ceremonial executive of the state, but not necessarily the office of the governor is to act. No, it always acts as the ceremonial head of the state. That is not always the case. And sometimes the office of the governor is acting in his discretion. Some are constitutional discretions along with the situational discretion that is present. So all the situational discretion that is there with the president, office of the president, when we look at all those situations that arises in the states, so in those cases the governor also enjoys those situational discretions. But not only does the governor enjoy this situational discretion, the governor also enjoys some constitutional discretion. So when it comes to the office of the governor, it is not practically, or not for all practical purposes, it is completely up to the governor. If the governor wants to enjoy some executive powers, he can enjoy those executive powers irrespective of the aid and advice that is given by the council of ministers. Clear? Have you understood this? This is the constitutional position of the governor, and when we compare the office of the governor to the office of the president, this is what it is. Clear? Write this. The office of the governor. You have written this? These are some very important facts. Though I am not explicitly discussing the qualifications that the governor has. I would like you to go through it. Just go through it. I know he should be the citizen of India. What are the qualifications, minimum, what is the age, all these factors that are there. Please go through that. Clear? Now, here give a subheading, right? Constitutional position of the governor. Constitutional position of the governor. The governor enjoys a constitutional position, which is far more secure than that of the president, vis-a-vis their respective council of ministers. The president enjoys mostly a ceremonial office. And his office is not primarily functional. He has influence, but no authority. His office is an office of dignity. His office is the office of dignity, but not authority. Further, the Constitution nowhere explicitly mentions that the president enjoys discretionary powers. His discretionary powers are more accidental or situational. The president cannot discharge his executive functions without the office of a council of ministers. On the other hand, governor's office is equally ceremonial and functional. His office has both authority and influence. Not only is the Constitution explicitly mentioning some discretionary powers that are enjoyed by the governor in which he does not require the aid and advice of the council of ministers, but the Constitution also prescribes for the governor of some states to enjoy some special responsibilities in which, though he is constitutionally obligated to consult the council of ministers obligated to consult the Council of Ministers, but is not bound by the advice of the Council of Ministers. Council of Ministers. Also, the office of the governor can exist and function. Give a subheading here, write discretionary powers of the governor. Discretionary powers of the governor. It is mentioned. That is what we discussed, 42nd and 44th Constitutional Amendment Act. It says that the Council of Ministers headed by the Prime Minister to aid and advise the President, such an advice can be sent for reconsideration of the Council of Ministers. After due reconsideration, the advice tendered to the President is binding on the President. This is what Article 74 says. Whereas under Article 163 of the Constitution, it explicitly mentions that the Council of Ministers will aid and advise the governor, and in certain cases the governor will act in his discretion until unless the governor wants to, or the Constitution wants the governor to act in his discretion. This has explicitly been mentioned. Discretionary powers of the governor. See, you have to remember these discretionary powers. Why? Two reasons. First, if you see 2015, if you go back to the year 2014 or 2015, in the prelims examination, this question was asked: which of the following are the discretionary powers of the governor? The question was very easy, but 80 to 90% of those who were appearing for that examination, they had marked that question wrong. Why? Because they tend to, they marked, there were out of the 4 options, one option was all of the above, and this is what generally almost 80 to 90% of them had marked this all of the above option, which is not the case, because the Constitution explicitly mentions what is the discretionary power of the governor, and in any of these cases, this is only the discretionary powers, where any other thing or in any other cases we cannot consider it to be the discretionary power of the governor. Clear? So what are those discretionary powers? First, under Article 163 clause 1, under Article 163 clause 1, the governor is to act according to the advice of the Council of Ministers, except insofar as under this Constitution, he is required to act in his discretion while discharging his executive functions. So Article 163 clause 1 explicitly mentions that he will have some discretionary powers. Next, under Article 163 clause 2, under Article 163 clause 2, if a question arises whether a power of the governor is discretionary or not, his decisions shall be final and binding. So it cannot be challenged in any court of law. This is what it means. It is up to him. Next, under Article 166 clause 3, the governor has the the governor has the power to make rules to make rules for the convenient transaction of business of the government of the state and the allocation of business to the ministers in this, under this article, allocation of business as well as making rules for convenient transaction of business is a part of the discretionary powers of the governor. Next, under Article 200, the governor of the state can reserve any bill passed by the state legislature, including the money bill, for the consideration of the president. Underline including the money bill. So when it comes to the office of the president does not have veto powers when it comes to money bill or constitutional amendment bill. In the state, the governor can even reserve a bill which is a money bill for the consideration of the president. It is not mandatory for the governor even to sign a money bill, which is not the case when we see this in case of the president. Clear? So the money bill that has been passed by the state can be reserved for the consideration of the president, and the president may just deny it. Absolute veto, he exercises, the office of the president exercises absolute veto when it comes to the state, and the states, any bill that is passed, even the money bill, can be absolutely denied by the president. A case in point being the Delhi legislature. Though the kind of control that the Council of Ministers or the President has over Delhi, that is special and different under Article 239AA of the Constitution. But otherwise also, if you see this, the state legislature, when it was formed in 2015, and since 2015 to 2017, mid of 2017, the Delhi legislature had passed 22 bills. All of these 22 bills were reserved for the consideration of the president by the lieutenant governor here, and the president rejected all of the 22 bills. Not even one bill was passed by the president. Absolute veto. The legislature cannot do anything about it. And under Article 200 of the Constitution, the governor has the power to reserve such a bill for the consideration of the president. So the governor does not reject the bill but reserves the bill for the consideration of the president. Next, under Article 356, under Article 356, the governor can invite the president to take over the administration of the state on the question of breakdown of constitutional machinery. So under Article 356, at any given point of time, the governor can recommend the president to take over the executive powers of the state on the question that the governor feels that the constitution cannot run in accordance to the administration cannot run in accordance to the constitution. So when the governor feels that administration cannot run in accordance to the constitution, this is what is called as breakdown of constitutional machinery. And in lieu of this, if the governor feels that any such thing has happened, it can invite the president to take over the administration of the state. Fortnightly report sends a fortnightly report to the president around 15 days to the president about the administration of the state. Such a report is prepared by the governor. Such a report is prepared by the governor in his discretion. Now see, explicitly speaking, these are the discretionary powers that the governor, office of governor, has. Coming back to this era, 1967, advent of competitive politics in India, leading to combative federalism. If you look at this idea of combative federalism, so the term combat, which means somehow they are in a state of war. So what was this combative federalism? This combative federalism meant that the center and the states, if there were two different parties that had come to power in the center and the state had a different political party that was in power, they were constantly in a state of war with each other. And in this combative federalism, in this phase of combative federalism, two of the most important tools that were present with the central government was the office of the governor. And through the office of the governor, there was absolute control that was exercised by the central government over the administration of the state. And also Article 356 of the Constitution, which empowered the president to take over the administration of the states. And frequently, not only was this article misused by the center, this misuse was not just done by one political party. That means, because majorly it was the Congress party that had enjoyed power till this 1994 mark. So we see that it is the Congress party which had to be held accountable for misuse of Article 356 of the Constitution. However, the Janata Party, which came to power in 1977, post-emergency, when they came to power, the Janata Party also did not spare the state governments. They also misused the office of the governor and Article 356 of the Constitution. In fact, one of the very important landmark events that happened, it happened post the demolition of Babri Masjid. So the governor of 3 states had recommended to the central government, to the president, that the president should assume the powers of the state government because the constitutional machinery of the state has failed. And the language that was there of the report, word to word, it was similar in all these 3 states. The report that was written by the governor, it was similar in all these 3 states. The language was absolutely the same. The only difference was the name of the state and the signature of the governor, which meant that this power that the governor has under Article 356 of the Constitution, and by being the executive head of the state, the office of the governor was being misused. It was the chief ingredient in this phase of combative federalism. Because when we say the president appoints the governor and the governor works on the pleasure of the president, what does that mean? For all practical purposes, it is the pleasure of the Council of Ministers. It's not the pleasure of the president, it is the pleasure of the Council of Ministers. And when we say the discretionary powers that are enjoyed by the governor, because the governor is working under the pleasure of the president, or for all practical purposes the council of ministers, so the discretionary powers that are enjoyed by the governor enjoys these discretionary powers informally with the consultation of the Central Council of Ministers. So whatever is dictated or whatever is directed by the center in exercise of these discretionary powers that the president that the governor has, that is what the governor does. And that is the reason why the office of the governor is said to be the agent of the center. It was not conceived in this manner. It was conceived that he will act as a link between the center and the state. So it will facilitate, the kind of federation that we were not an ideal federation. The territory of India, it was, it's huge. So to ensure that better governance and better coordination between center and the state continues, this is how we conceived the office of the governor. And to ensure, obviously, the historical baggage that we had. If we would have allowed the states to enjoy absolute sovereignty, obviously it would have been misused. And the states, frequently, as it is, there is a problem with respect to the integration of India. So these states, if they would have had sovereignty, so they will always, they would always question the sovereignty of India. And so that this does not happen, we conceived the office of the governor. But the mechanism in which it was used, the powers that it was used for. In 2015 itself, simultaneously, that is along with the state of Uttarakhand, there was also emergence, the precedence rule which was imposed in the state of Arunachal Pradesh. The emergency was imposed in the state of Arunachal Pradesh because, again, the governor had written a report to the president claiming that the constitutional, the constitutional machinery in the state's administration cannot run in accordance to the constitutional machinery. What was the reason? Yes, the governor had a valid reason. The governor of the state said that the constitution says that there shall not be a gap of 6 months between two sessions of the legislature, and the concerned government has not appropriately advised the government for governor for convening the or to summon the state legislative assembly. So he invited the president. In both of these two cases, that is in Uttarakhand as well as in Arunachal Pradesh, interestingly, coincidentally, the Congress government was there, which means at the center there is the NDA government had already come to power, and in the state the Congress government was there. And the governor had recommended to the president. In both the cases, the president imposed precedence rule, and in both these cases it was overturned by the Supreme Court. The Supreme Court felt that the conditions that were present, the conditions did not mandate for imposition of precedence rule. In both these cases, it was overturned. However, a very interesting thing also happened when the Supreme Court was giving this decision. So the Supreme Court, when it was giving its decision in the case of Arunachal Pradesh, the bench that was there, it in its recommendation, in its decision, mentioned that the state legislative assembly is to be reinstated and the council of ministers are to be reinstated. Further, it added a particular sentence. It said that the governor of the state should not have recommended the president for imposition of precedence rule. The language was different, the meaning of the sentence was same, and this was a line that was added in the decision that was given in Arunachal Pradesh. The next day, the Supreme Court revised its decision and it removed this sentence from the decision, and it said that it is a discretionary power of the governor and the court has no authority to direct the governor to do or not to do something. So it's a discretionary power of the governor. Yes, the court can interpret it in accordance to the constitution, ensuring that the constitutional provisions are not violated, but we cannot direct the governor to do or not to do something. Which means the Supreme Court basically upheld the idea that there are some discretionary powers that the governor has, and while exercising such powers, the governor will act in his discretion. Clear? These are the discretionary powers that the governor has. Next, give a subheading and write special responsibility of the governor. No, not portfolio. It is about allocation of business and convenient transaction. So certain rules, regulations can be made, but not portfolio. It is portfolio is the discretion of the advice of the chief minister, not portfolio. Special responsibility of the governor. Now we have just seen how does the governor discharge his special responsibility. He consults the council of ministers, the aid and advice consultation process that is there, it is mandatory, but it is not binding on the governor to act in accordance to the advice that is given by the governor. Clear? First point here. The governor of the state of Maharashtra and Gujarat, under Article 371 Clause 2, have a special responsibility for the establishment of a board for the Vidarbha and Marathwada region. Vidarbha and Marathwada region, and for the rest of Maharashtra, comma, the Saurashtra and Kutch region, and for the rest of Gujarat, respectively. See, you know that this particular region, Vidarbha region that is there, or the Marathwada region that is there, they are in terms of development, that is not a lot. The region, one of the reason is that it lies on the leeward side of the Western Ghats. Because of it lying on the leeward side of the Western Ghat, rains etc. are not there, leads to frequent droughts etc. etc. So for this particular region, there is a board that is established by the governor of Maharashtra, and for the rest of the rest of Maharashtra, there is a board that is established which looks into this very matter, the development etc. Similarly is the case with Gujarat as well. The Saurashtra and Kutch region, for them there is a separate board that needs to be established, and for the rest of the Gujarat there is a separate board that needs to be established to look into certain matters that concern the particular state. This was introduced because of initially the Bombay province that was there. It included the Maharashtra and parts of Gujarat. It included that particular region. Later on it was separated when we came up with linguistic division of states, so these two states were also separated. So after this separation, there were some special powers that were given, not after, sorry, it was since we included it in the constitution, there were some special responsibility that was given to the governor. Clear? Second, under Article 371A, Clause C, subclause B, 371A, clause C, subclause B, the governor of Nagaland, has a special responsibility to maintain law and order in the state till the unrest caused by Naga rebels is in existence. So law and order, governor of Nagaland has the responsibility to maintain law and order. Unlike other states wherein it responsibilities with the state government and the state legislature, here the responsibility lies with the governor of the state. Obviously, you know the Naga rebellion that is there, the Naga insurgency, things such as the groups NSCN, recently Naga Peace Accord, you must have read about these things. Next, third, under Article 164, the governors of MP, Odisha, Jharkhand and Chhattisgarh have to ensure that a separate ministry for tribal welfare is established. The 94th constitutional amendment in 2006 amended Article 164 removed the name of Bihar and added Jharkhand and Chhattisgarh to Article 164. So in 2001 there was division of states. Bihar was divided into South Bihar became Jharkhand. Similarly, MP was also divided. There was a part carved out of it. It became Chhattisgarh. So these two names were added and the state of Bihar the name was excluded. Clear? So these are the special responsibilities that the governor enjoys. When we say special responsibility or discretionary powers of the governor, actually it's not the discretionary power of the governor or the special responsibility of the governor, it is basically the discretionary power of the Union Council of Ministers, because any such powers that are enjoyed by the governor, because the governor works on the pleasure of the president, it is basically the Union Council of Ministers who enjoy such powers. Clear? Now, the office of the governor is one of the most criticized offices when it comes to India's federation. That means whenever we talk about India's India's unitary tilt, now we describe India's federation to have a unitary tilt. And if you look at that unitary tilt, one of the reasons for this unitary tilt is the existence of the office of governor. Why? Because federation, the principle of federation dictates that there shall be division of powers and autonomy that should be given to the states, and that is not the case when it comes to when we look at the office of the governor. We feel that the office of the governor, the objective of the office of the governor is to act as the agent of the center. So when we are pointing out to that unitary tilt, one of the most important reasons why we can say yes, there is a unitary tilt is the office of the governor. It is the office of the governor. And that is the reason why in India, there have been two center state commissions that have been formed. In the 1980s, to be more exact, 1983, the Sarkaria Commission was formed, and the Sarkaria Commission recommended on how to improve center-state relations. No, because center-state, when we come to center-state relations, you will find that this relation between center and state, they are not always very good. No, they are not always very good. Like you can see the state of West Bengal and the union as of now. You can see the relation that is there. During general elections, there was a cyclone that hit the eastern part of our country. I don't remember the name of the cyclone. Hudhud or something like that, I think. Something like this was the name. Yes? That was the case. So when the Prime Minister, because despite the elections are going on, results have not been declared, but he is the Prime Minister. So to ensure that there are certain relief measures that are taken for those states that are affected by it. So West Bengal, Odisha, these, and obviously Andhra Pradesh, these were some of the states that were primarily affected by it. So the Prime Minister called upon the chief ministers of all these states to see as to what is the level of preparedness, and was a need for any kind of assistance that should be given to the states. The Chief Minister of West Bengal did not receive the phone call of the Prime Minister. She did not receive the phone call of the Prime Minister. This in itself, in accordance to the Constitution, is a valid ground to impose President's rule. This in itself, according to the Constitution, is a valid ground to impose President's rule. You must have seen about the CAA protests, and Mamata Banerjee made a statement, said that the protection of railways is not the responsibility of the state government. Absolutely wrong. She cannot make that statement in front of a court. Okay, politically she said that. But the Constitution says that the center can direct the state for maintenance of railway property, and the state has to adhere to such directions. If the state does not, it becomes a valid ground for proclaiming President's rule. The Supreme Court also accepts this reason. So the constitutional language is such, and the constitutional provisions between center-state relations are such, that we have a unitary tilt. We have a unitary tilt. And this unitary tilt becomes much more visible through the office of the governor. So while the Sarkaria Commission was recommending on center-state relations, it gave due importance to the office of the governor. It gave due importance to the office of the governor and recommended a number of reforms as to how the office of the governor, or who should be appointed to the office of the governor. Before the 1960s, more appropriately before this very year 1967 that we were talking about, when the governors were being appointed to the states, two conventions were followed. First was that the center will not appoint an individual or an insider to holding the office of the governor. So he will be an individual who will be an outsider, not belonging to that particular state. This was a convention that was followed. Secondly, the chief minister of the state will be consulted when the governor was to be appointed. 1967, in the era of combative federalism and the centralization of powers, Indira Gandhi being there, she started violating these conventions, and since then this convention has been violated. Now this convention, it's almost forgotten that okay, there was some convention also. It's absolutely over. Sarkaria Commission specifically recommended that the governor should always be an outsider, and any individual who has been an active politician, shall never be appointed as the governor. at least, at least there will be a gap of 2 or 3 years. Since an individual has left active politics, only those individuals should be appointed as the governor. Similarly, they also recommended that while exercising its functions, the governor, that when it is exercising its functions, it will ensure that the governor whenever he recommends the president's rule, in that case it should be done in writing. It should be done in writing and the reasons should be quoted. What are the reasons why you are recommending president's rule? And number of other reforms that were recommended by the Sarkariya Commission to somehow improve the mechanism in which the office of the governor, or the manner in which this office of the governor was being used. Because we are talking about the 1980s, and what did I say? Till 1994, which means till this particular point, this office of the governor was considered, he was being used as an agent of the center. And that was the reason why during this particular period, even today, but not as it was the case when it comes to the 1960s till the early 1990s. This was a period wherein the office of the governor, who is appointed as the governor, one of the problems that occurred between the center-state relationship was this, that who is being appointed as the governor. And generally, you will find governor, who is appointed as the governor? Retired politicians. That means they are no more of, suppose a political party is, the political party feels that, okay, this individual is no more, either he is not any more capable of, or he is no more politically so relevant. So he is appointed as the governor. And frequently you will find, this appointment is done of active politicians. Let's take an example. Sheila Dikshit. When she lost elections in Delhi and the Aam Aadmi Party came to power, the Aam Aadmi Party, when they were campaigning for elections, they proposed that the Commonwealth Games that were held in Delhi, there were number of cases of corruption that had come up in organization of Commonwealth Games, and Aam Aadmi Party said that we are going to register an FIR and against the Chief Minister and conduct an inquiry. Cases of corruption are criminal offences in India. Sheila Dikshit was transferred as the governor of Kerala. Now, can a criminal case be registered against a governor? No. So, she was the chief minister till very recently. She was made the governor of Kerala. Similarly, Arjun Singh, who was the HRD minister during the first UPA government, as soon as he completed his tenure, the first UPA government completed his tenure, he was appointed as the governor of, I think, Rajasthan or some state. He was a union minister and he was appointed as the governor of Rajasthan. Similarly, if you look at Kiran Bedi, right now she is the lieutenant governor of Puducherry. She was till very recently, in the last elections that happened in Delhi, she was the chief ministerial candidate of the BJP. She was the chief ministerial candidate of the BJP. Not only that, the constitution also says, the constitution, there are some positions, when you hold certain positions which are constitutional positions, and such offices in which it is considered that those individuals who are there, they are to act independently, under no influence of the executive. Even those individuals, there have been some traditions of even appointing those individuals to the office of governor. Like in members of UPSC, there was a member of UPSC, some Paul. He was the commissioner of Delhi. He was a commissioner of Delhi police commissioner. After being the Delhi police commissioner, when he retired from being this position, he was appointed as a member of UPSC. Now, UPSC is considered as a body which protects merit system in India. So it should not be under any kind of influence of the executive. After he completed his tenure as a member of UPSC, he was appointed the governor of one of the states in Northeast. That should not happen. Now, though the constitution prohibits it, the constitution says that members of UPSC, they can only be, they are only qualified to hold some offices, and for other offices they cannot hold offices under the government of India or under the government of state. But interestingly, such members are being appointed to the office of governor. And when you look at the Supreme Court's decision, see, Supreme Court हमारे यहाँ और महान है, उन्होंने क्या कहा देखो, the office of the governor does not come under the employment of the state. So this was challenged. It was challenged that how can you appoint such individuals to such offices? The Supreme Court's decision is there. The Supreme Court says it cannot be considered as an employment under the government of the state or the government of India. Now, why is it not an employment? The president is appointing to this position, he is receiving salary, allowances, all these things. But such an appointments are being made. You can look at the nature of influence that the executive, the central executive, the union executive has over the office of the governor. So, such individuals, how can you appoint? Supreme Court judge has been appointed to the governor, to being in one of the offices of the governor. How can you appoint the Supreme Court judge to be a governor? It means that there is something called as separation of powers. To properly maintain this idea of separation of powers and to have to ensure that it continues in existence in a certain manner, we need to ensure that such traditions are not followed. But it is, and Supreme Court is very ready to do that. Supreme Court says office of the governor is not under the employment of the state. तो एम्प्लॉयमेंट का क्या मतलब होता है फिर? 1.5 लाख, आप 1.5 लाख रुपए सैलरी दे रहे हो एंड यू से यू आर नॉट अंडर द एम्प्लॉयमेंट ऑफ द स्टेट. See, this is what happens, and this is what was the specific recommendation that the Sarkaria Commission gave, that such an influence that is there, it should not be enjoyed, and there should be various mechanisms that should be taken up. Because it was a report of 1987, so I am not discussing that report. But now in India, such commissions are made just for the name of making such commissions, appointing such commissions. None of the recommendations of Sarkaria Commission was implemented. So what happened was in 2008-9, again a commission was appointed called as the Punchi Panel or the Punchi Commission on center-state relations. Now Punchi Commission also recommended on the office of the governor, because obviously I said it is the link between the center-state relations. So they also recommended on the office of the governor. But unlike the Sarkaria Commission said that though there should be certain measures that should be taken for appointing the office of, to an individual to the office of the governor, but they still agreed that the office of the governor should act on the pleasure of the president. There should not be tampering with this particular provision. They should act on the pleasure of the president. The Punchi Commission does what? The Punchi Commission goes against this principle. There are number of recommendations that are given by Punchi Commission on the office of the governor, but one of the most important recommendation that it gives is, it says that the governor of a particular state, though he is being appointed by the president, but should not act on the pleasure of the president, and he should be impeached by the state legislative assembly, the state legislature, like the impeachment is done of the president. तो देखो कुछ ऐसे लोगों को commissions वो बना दिए जाते हैं, they recommend certain things which can never happen. See, how is it feasible? The center appointing the governor and the state impeaching it. So impeaching the governor, if that goes, so no, at every day there is an impeachment that is passed. Why? Unless the state gets a governor which either belongs to that political party, till that particular time the impeachment process is going on. So Punchi Commission came out with their own innovation, and they recommended something which will not be ever implemented. Though yes, they gave some very important recommendations, such as the governor should not be appointed as the vice chancellor of universities. The governor, again, like Sarkaria Commission, they also proposed certain ideas to maintain the independence of the office of governor, so that he does not purely act as the agent of the center. But certain recommendations that were given, they were not feasible in terms of its implementation. And that is what happened. The recommendations of Punchi Commission came in 2010, 10 years, we have already passed 10 years, and there has been no implementation of it. Though in 2019, the outgoing Home Minister, that is Rajnath Singh, did initiate, he in one of his events, he actually initiated that, okay, let's initiate a debate on the recommendations of Punchi Commission and look at the feasibility of its implementation. But because the government changed, obviously, now he's no more the Home Minister, and there was no deliberation on what he had to say then. Clear? So I'm not going into the details, I'm not dictating each and every recommendations of Sarkaria and Punchi Commission. I want you to go through the recommendations, specifically when it comes to the office of governor. When I come to center-state relation, yes, I'm going to discuss some provisions of Punchi Commission, but in the office of the governor, what recommendations were given, you can go through it. Clear? This is the office of the governor. So complete control of the union over the office of the governor. Now, there is no need to discuss the Council of Ministers and Chief Minister, because the provisions are the same when it comes to the Prime Minister and the Council of Ministers. The only difference is in articles. So the number of articles, article number changes, otherwise all the provisions remain the same. So please go through it. I am not going to discuss the Chief Minister, etc. As it is, you must have received a booklet. If not, you will get it, and it contains that chapter, Chief Minister and the Council of Ministers. So you can go through that, or you have Lakshmikant as it is. Next, let's start with the state legislature. Let's start with our discussion on state legislature. So in India, how many states are there? State legislature. Now, when we are talking about state legislature, let's start with our discussion on this very idea, that is Article 169 of the Constitution. Article 169 of the Constitution, which deals with what? Which deals with abolition and creation of upper house. Now, what does this idea actually mean? In India, at the state level, we have an existence of two types of political system. That means, in terms of legislature, two types. Most of the states in India are unicameral legislature. That means they have only one house called as the state legislative assemblies. And these state legislative assemblies are there in all the state legislatures. However, there are some states in India which also have a bicameral legislature. That means in some states we also have an upper house called as the State Legislative Council or Vidhan Parishad. Okay, Vidhan Parishad. So there is something called as Vidhan Sabha and Vidhan Parishad. Vidhan Sabha is the state legislative assembly, and Vidhan Parishad is the state legislative council. But this is something that is not a guarantee, which means not all state legislatures are not bicameral. There are only some state legislatures which are bicameral state legislatures. Some state legislatures, like if you look at the state of Bihar, if you look at the state of UP, if you look at the state of, I think Karnataka, there are then there is the state of Andhra Pradesh and Telangana. They are the bicameral legislature. So there are some states which have bicameral legislature, but most of the states, whether it is northeastern states, whether it is the states of Punjab, Uttarakhand, your Himachal Pradesh, or for that matter the states of Goa, all these states that are there, they do not have a bicameral legislature, they have a unicameral legislature. Sometimes this question is also asked, so please go through it. Previously the state of Jammu and Kashmir, because it was a state, so it had a bicameral legislature. Now it is no more present. Now with it having a UT, it's very likely that it gets a unicameral legislature and not a bicameral legislature. Clear? When we talk about Article 169 of the Constitution, Article 169 of the Constitution provides for the procedure through which the upper house or the state legislative council or the Vidhan Parishad can be created or abolished. The same procedure is mentioned in the Constitution, Article 169. The same procedure is used for creation of a upper house, or for that matter for abolishing an upper house. What is the process? The process says that the power to create an upper house for the state lies with which body? It is the Parliament of India which enjoys the power. The Parliament of India enjoys the power to create an upper house at the state level as well. So it's completely dependent upon the Parliament. However, the process can only be initiated by the State Legislative Assembly. So when the State Legislative Assembly passes a resolution by a special majority, so now when it passes a resolution by a special majority, now the Parliament is authorized to create a upper house or abolish a upper house. However, it is not mandatory for the Parliament. Even if the State Legislative Assembly has passed a resolution with a special majority, it does not mean that now the Parliament can be compelled to create a upper house or abolish a upper house. No. It is the discretion of the Parliament. So the process is always initiated by the State Legislative Assembly. Once the State Legislative Assembly has passed a resolution to this effect, it goes to the Parliament, and now it is the discretion of the Parliament. So the Parliament may or may not create an upper house. So in certain cases, like if you look at the states of Tamil Nadu. Now if you look at the states of Tamil Nadu and the state of Andhra Pradesh. So in the state of Andhra Pradesh, the upper house was created in 2007. Similarly, the state of Tamil Nadu also sent a resolution to create an upper house in I think 2007-8, but the Parliament did not create that. So it provided for an upper house to Andhra Pradesh, it did not provide for an upper house to Tamil Nadu. It is completely up to the Parliament. So if you get a question, which of the following creates the upper house, the answer to it is Parliament. If the question is which of the following authority initiates the process of creation or abolition, the answer is State Legislative Assemblies. Clear? This is what is mentioned under Article 169. State Legislative Assembly, State Legislative Council, and this abolition and creation and number of membership etc. that is there. If you see the last 2-3 years, every year in your prelims examination there has been a question that has come from this. So you can always expect a repetition of this idea and you get a question from this particular topic, because it has been followed in the last 2-3 years, every year. Clear? Write this 169. under Article 169, it is the Parliament that enjoys the power to create, or abolish the upper house by a law. However, the Parliament can pass such a law only upon a resolution passed by the State Legislative Assembly to this effect, supported by a majority of not less than two-thirds members present and voting, and a majority of the total strength. However, the Parliament is not bound to pass a law. Next, give a subheading, right? Composition of upper house. Now, when it comes to the upper house, that is the Vidhan Parishad or the State Legislative Council, what does the Constitution prescribe with respect to the composition, maximum and minimum? The Constitution says the State Legislative Council can have a maximum strength of 1/3 of the State Legislative Assembly. A maximum strength of 1/3 of the State Legislative Assembly, and a minimum strength of 40. So there cannot be less than 40 members to the State Legislative Assembly, but there can also not be, the number cannot exceed 1/3 of the total of the State Legislative Assembly. Which means what? Which means some of the states in India, some of the smaller states in India will not have, can never have, according to this constitutional provision, till the time this constitutional provision exists, they are not going to have a State Legislative Council. Example, the state of Punjab. How many members do they have in legislature? It is State Legislative Assembly. It is, I think, 119 or 118. Now, can this particular state have a State Legislative Council? No. Why? Because when we take up 1/3, which is the maximum strength, it will be less than the minimum strength that should be there. So, northeastern states, they have, some states have 60 members, some states have 30 members. Now, these states also cannot have legislative council. The state of Goa cannot have a legislative council. Only those states which have more than 120 members in the legislative assemblies, only those states can have a legislative council. Clear? So you will find that states of Punjab, depending upon the kind of strength that they have as of today in the legislative assembly, they cannot have a legislative council. Now, what is the composition? Right, composition. This is the maximum and minimum strength. But how is this distribution of seats happen? Let's look at that. First, not more than 1/3 of the members, not more than 1/3 of the members, 1/3 of the members shall be elected by local bodies, shall be elected by local bodies. Clear? So they are elected by local bodies. Second, not more than 1/3, not more than 1/3 shall be elected by the legislative assembly of the state, legislative assembly of the state, from amongst the members, from amongst the people, from amongst the people who are not the members of legislative assembly, who are not the members of legislative assembly. Clear? Next, not more than 1/12, not more than 1/12 shall be elected by graduates of at least 3 years standing for ordinary residents of the state, standing for ordinary residents of the state. Next, not more than 1/12 of the members, not more than 1/12 of the members shall be elected by teachers, shall be elected by teachers who are not lower in rank, who are not lower in rank than secondary grade teachers, secondary grade teachers who are ordinary residents of the state, who are ordinary residents of the state. And fifth, the rest of the members are nominated by the governor, rest of the members are nominated by the governor amongst person who have special knowledge, amongst person who have special knowledge or practical experience, or practical experience in arts, literature, science, social service and cooperatives. So see, in this case what is basically happening? There are some individuals, these individuals that are there who are to the these individuals are elected by 4 category of individuals. First 2 categories, that is 1/3, at least 1/3 that are there, these categories are basically elected members. So either they are elected by from local bodies or they are elected to the state legislative assemblies. So they have the right to elect individuals to the legislative councils, but the maximum number of individuals that can be elected by them is 1/3. Then comes 2 other categories in which teachers and the graduates of at least 3 years, that means they should be graduates of at least 3 years, and there should be teachers who are not less than secondary grade teachers. They elect not more than 1/12 of the members. But how do they elect that? They are, in that case, in that capacity, they are electing members acting as ordinary residents. That means not all ordinary residents are allowed to vote. Only these individuals are allowed to vote. Whatever number of seats are remaining, in that case, that will be appointed. There the nomination facility works, and accordingly they are being nominated by the governor of the state. And there are 5 categories that are mentioned. Go back to the nomination of president, and if you compare the nomination of governor, there is a difference between the categories that are mentioned. So in the when the president is nominating 12 members to the Rajya Sabha, there are 4 categories that are mentioned: science, art, social service, etc. There is a cooperative. This term cooperative that is there, it is something that is mentioned when it comes to the legislative council. Clear? Next comes legislative assemblies. Legislative assemblies. See, the legislative assemblies, Constitution also prescribes for what is the maximum and minimum strength of legislative assemblies. And the Constitution prescribes that legislative assemblies will have a maximum strength of 500. The minimum strength that is there is 60. How many members are there in the legislature of Nagaland? You can search the net, you will find it will be less than 60. कुछ नॉर्थ ईस्टर्न स्टेट्स हैं, there are less than 60. Why? Because the Constitution also says, the Constitution also prescribes that the president can make special concessions for some smaller states. You write this. However, the president can provide for the strength of less than 60 members in legislative assemblies for smaller states. Nagaland has 60. Some smaller states. The governor can also nominate not more than one member from the Anglo-Indian community to the legislative assembly if the community is not adequately represented in the legislative assembly. You can check this provision. I am not sure 104th constitutional amendment, did it remove this nomination provision or not. I'll check and I'll inform you tomorrow. But currently, according to my knowledge, this is still there. In Lok Sabha it is no more there, but according to my knowledge it is still there in the states. But I'll just confirm it once and I'll inform you. Clear? And again, like the Lok Sabha, the whole of the state is divided into constituencies, single member constituencies, and accordingly individuals are elected. Clear? This is the legislative assemblies. Now comes the most important part of our discussion, which is the constitutional status or position of legislative councils. Give this as a subheading, right? Constitutional position of the legislative council. Constitutional position of the legislative council. If you remember, we did discuss this very idea when we were also discussing the Rajya Sabha. What is the constitutional position of the Rajya Sabha? And based on a discussion, we concluded that the Rajya Sabha is based on the principle of equality of houses, and hence the legislative powers of the Lok Sabha are equal to that of the Rajya Sabha, except for obviously the financial power and in case of the political control. But the reasons are different there. Now the Council of Ministers are only responsible to the Lok Sabha there because the Council of Ministers, the body is formed because of the majority that they get in the Lok Sabha, and because the Rajya Sabha is a council of state and state have their own autonomy with respect to managing their finances. That is the reason why they are not given that power in the center. We did discuss this idea in the last class itself. Now let's compare that idea. If we say that the upper house in the center, Rajya Sabha in the center that is there in the Union Legislature, it has equal powers to that of the Lok Sabha. Can we assume or can we say the same for the legislative councils? Can we say that the legislative councils also have the same legislative position as that of the legislative assemblies? This is something that needs to be seen. The answer here is no. That is not the case. That is not the case. Why? Because if you look at the legislative powers of the legislative councils and compare those powers to the Rajya Sabha, you will find that the Rajya Sabha, when it comes to ordinary bill or when it comes to constitutional amendment bill or when it comes to the financial bill, they enjoy equal powers. That is not the case when it comes to the legislative councils, even in case of an ordinary bill. See, money bill, obviously, like the position that is there in the Rajya Sabha, in the Union Legislature, the same position is also present in the State Legislature. So the money bill is always introduced in the Legislative Assembly. Once passed by the Legislative Assembly, goes to the Legislative Council. Maximum what the Legislative Council can do is delay it for a 14-day period. Now when it comes to an ordinary bill, if we look at how the passage of ordinary bill takes place, in that context we can understand that how or why are we saying that the Legislative Council does not enjoy the equal legislative position. Because suppose an ordinary bill is first. The first scenario is, suppose an ordinary bill is introduced in the Legislative Council. It is passed by the Legislative Council. It is transmitted to the Legislative Assembly. And if the Legislative Assembly defeats the bill dies. If the Legislative Assembly defeats the bill dies. On the contrary, if the bill is introduced in the Legislative Assembly and is passed in the Legislative Assembly, it goes to the Legislative Council, and the Legislative Council has 4 steps, or it has 4 options. What are those options? Obviously, it can approve or pass the bill. If it approves or passes the bill, it directly goes to the governor, and the governor can now give his assent to the bill. The second condition is that the Legislative Council can reject the bill. The Legislative Council can reject the bill outrightly, or third is the Legislative Council can suggest amendments. It does not take any action for 3 months. If the Legislative Council does not take any action for 3 months, that means in these two cases, either the Legislative Council has rejected the bill, or the Legislative Council has not taken up any action for 3 months after the bill has been passed by the Legislative Assembly and has been sent to the Legislative Council. In these two cases, the bill will be transmitted back to the Legislative Assembly. The bill is transmitted back to the Legislative Assembly, and if the Legislative Assembly passes the bill again, the bill is retransmitted to the Legislative Council. The bill is retransmitted. So the Legislative Assembly has passed the bill, goes to the Legislative Council. The Legislative Council has either rejected the bill or has taken no action for 3 months. In that case, the bill is retransmitted to the Legislative Assembly. Legislative Assembly again passes the bill. In this case, the bill again goes to the Legislative Council. No, the Legislative Council receives the bill for the second time, and this time they are given a tenure of 1 month. That means at the expiry of 1 month, since the bill has been retransmitted or transmitted for the second time to the Legislative Council, at the expiry of 1 month period from that day, it is deemed that both the houses have passed the bill. It is deemed that both the houses have passed the bill. Whether the bill is defeated again, whether the bill is passed or whatever, they are given 1 month period. If they pass the bill within 1 month period, fine. If they do not do anything, that is also fine. Even if they reject the bill for the second time, that is also fine. The bill will be there for 1 month, and after 1 month it will be deemed that it has been passed by both the houses. Clear? The fourth option is that the Legislative Council suggests amendments. The Legislative Council suggests amendments. Now, in this case again, the bill is again transmitted to the Legislative Assembly. Now, Legislative Assembly has two options. First, to accept the amendments. That means all the amendments are accepted by the Legislative Assembly. The second is that the Legislative Assembly rejects one or more amendments. If the Legislative Assembly accepts all the amendments, it goes back to the Legislative Council. In this case, it goes to the governor, and the governor may give his assent to the bill, because now both the houses have passed the bill. In this case, wherein the Legislative Assembly has rejected, even if one or more than one, that means all of them can be rejected as well. In this case, the bill goes back to the Legislative Council and they are given 1 month. After the expiry of 1 month, since the bill is retransmitted to the Legislative Council, it is deemed that both the houses have passed the bill. It is deemed that both the houses have passed the bill. What do we see here? What do we observe here? Just compare this provision to the powers of the Rajya Sabha. Now, in this case, if an ordinary bill is passed by the Rajya Sabha and it goes to the Lok Sabha, and Lok Sabha rejects the bill, can we say the bill is dead? Then what do we say? If the bill does not die, then what happens? What is the term that we will use? Lapse? No. The Lok Sabha has passed the bill. The bill is transmitted to the Rajya Sabha. The Rajya Sabha has defeated the bill. What do we say? A deadlock has appeared. We say a deadlock has appeared. Do we say that the bill is dead? No. Unlike the provision that is the case here. See, Legislative Council has passed the bill, goes to the Legislative Assembly defeats the bill dies. No deadlock. There is no deadlock like the case that is there in the Rajya Sabha. Now see this. Suppose the Lok Sabha passes the bill. It goes to the Rajya Sabha. And Rajya Sabha, obviously if it passes the bill, it goes to the governor. If the Rajya Sabha rejects the bill, or the Rajya Sabha does not take any action for 3 months, what is the term that we use? Then what is the term? There it is. The time is 6 months, I think. The time is 6 months. Yesterday we were discussing this idea. Again, deadlock. That means in these two cases there is a deadlock. Can this deadlock be resolved? Yes, through a joint sitting. If Rajya Sabha suggests amendment and it goes back to the Lok Sabha. So Lok Sabha, if the Lok Sabha rejects some amendments, all or any, even one of them, so is the bill dead? No. Again we say the deadlock has happened. And in all these three cases, there can be a joint sitting that can be called for, and this joint sitting can be resolved by a simple majority. But the Rajya Sabha and the members of Rajya Sabha in the joint sitting, they get an opportunity. They get an opportunity, if they do not like the bill, they get an opportunity to debate, discuss them, and again put forward their views. And that is the reason why we say that the powers that are enjoyed by the Lok Sabha and the Rajya Sabha are similar. In this case, see what is happening. In these two cases, when it is being rejected by the Legislative Council, or no, the Legislative Council has taken up no action, in that case the bill is going to the Legislative Assembly. Legislative Assembly, if it passes the bill, again it is retransmitted to the Legislative Council and they are given 1 month period. कुछ करो ना करो कोई फर्क नहीं पड़ता. You have no authority once the bill has again been passed by the Legislative Assembly. This is not the case when it comes to the Rajya Sabha. Similarly, if amendments are suggested, and such amendments are not agreed upon by the Legislative Assembly, in that case again it passes the bill and it is retransmitted, and then also Legislative Council does not have any authority. But in this case, in Rajya Sabha, when Rajya Sabha has suggested an amendment, it goes back to the Lok Sabha. If Lok Sabha does not agree, it does not mean that the bill is passed. It means a deadlock has again appeared. So if you compare the legislative authority, the legislative jurisdiction of the Rajya Sabha to that of Legislative Council, we do not see the same powers. And that is the reason why when we talk about the constitutional position of the Legislative Council, we say it is not based on equality of houses. The principle is not equality of houses. Rather, the Legislative Council is not only the second chamber, it is also the secondary chamber. We said Rajya Sabha is the second chamber but not the secondary chamber. But Legislative Council is not only the second chamber, it is the secondary chamber as well. What can the Legislative Council maximum do? Delay the process. That's it. Legislative Council, the members of Legislative Council can only delay the process and somehow pray that Legislative Assembly will change its opinion. That's what they can do. So in terms of authority with respect to passing legislative jurisdiction, it is not equal to that of the Legislative Assembly. Yes, it may enjoy some moral authority. It may so happen that because it takes a period of the whole process may take 3 months. So passed by 15 days it takes to pass the bill, 3 months, and again it is transmitted to the Legislative Assembly, it passes the bill and it goes, so in total 5 month period or something like that. They can just delay this process. And they may, because they may enjoy some moral authority, so it may so happen, they may enjoy some moral authority, so it may so happen that the Legislative Assembly changes its opinion. But by virtue of its legislative position, or by virtue of the legislative powers that the Legislative Council has, they cannot either amend or reject. They cannot either amend or reject any law or any bill that has been passed by the Legislative Assembly. Understood this idea? So maximum, what is the purpose that it serves? That yes, there is a nomination facility available. So recruitment of talent in the Council of Ministers and enjoying some kind of moral authority. But moral authority is not there in polity. So there is no such thing as moral and ethical. Okay, morality and ethics don't work. That is basically, it's not to be laughed upon. See, how can they work on morality and ethics? That is also something that needs to be seen. How can they work on morality and ethics? The legislature acts on reality. It is a realistic organization. It cannot work on morality and ethics. You know, let's look at, yes, there may be the laws that are being proposed. Yes, it may have a morality component, an ethical component, but you cannot expect the legislature solely to base its opinion on these ideas. Okay? Now, when this CAA protests that are going on, okay, यही तो बात है. आप सोचते हो, आप ये एज्यूम कर रहे हो कि लेजिस्लेचर मोरालिटी और एथिक्स पर काम करेगा. ऐसा होता नहीं है. दैट इज नॉट हाउ इट वर्क्स. दैट इज नॉट हाउ इट वर्क्स. द लेजिस्लेचर एंड द गवर्नेंस ऑफ द कंट्री वर्क्स ऑन रियलिटी, नॉट ऑन द बेसिस ऑफ अज्यूम्ड एंड प्रिज्यूम्ड नॉर्म्स. यही तो कर रहे हैं ना ऑपोजिशन. व्हाट दे आर ट्राइंग टू डू, दे आर ट्राइंग टू अज्यूम एंड प्रिज्यूम थिंग्स. ऐसा हुआ है या ऐसा हुआ होगा. That is not how laws work. That is not how administration is carried out. Clear? So this is the constitutional position of the legislative council or the upper house in the state legislature. Clear? Write this down. Procedure. Legislative procedure. A money bill is passed. At the state legislative level, in the same manner as it is passed in the parliament, An ordinary bill passed in the upper house, when transmitted to the lower house, and if the lower house rejects, when the lower house rejects the bill, it comes to an end. The bill goes back to the lower house, and if passed for the second time, it is retransmitted to the upper house. And on the expiry of 1 month, after receiving the bill for the second time, it is deemed to have been passed by both the houses. Fourth option. If the upper house suggests amendments, then the bill goes back to the lower house, and if the lower house accepts all the amendments, it is deemed to have been passed by both the houses. On the other hand, if the lower house rejects one or more amendments and passes the bill for the second time, it is retransmitted to the upper house, and at the expiry of 1 month period, the bill is deemed to have been passed. By both the houses. Next paragraph. Thus, the upper house cannot reject or amend the bill passed by the lower house by virtue of its own legislative powers. Clear? This is the legislative procedure, and from this itself you can derive what is the constitutional position of the upper house. So write down a question here and try and answer this question. Write down a question here, try and answer this question. This question is about the constitutional position, and so that this though I have not explicitly talked about the constitutional position of the second house, I have talked about legislative procedure, but you can derive it from there. Write down the question. Comparing the legislative jurisdiction of the Rajya Sabha and the state legislative councils, we can conclude that though that Rajya Sabha is based on principle of equality of houses, but the same is not true for state legislative councils. The same is not true for state legislative councils. Comment or elaborate, whatever. See, right now I said that the administration of the country does not work on ethics and morality. Don't write this in your paper. No, sometimes, whatever I say, you tend to write it. Don't do this. This is something that is to be understood. Clear?